it's passed back and forth. Same with your PDFs, make sure it's signed by the buyer and sent back to everybody. With your listings, another one with your listings that we have, make sure that the listings have to be signed by the office. Otherwise, it's not a complete contract. So remember that when you send us the listing, your listing with individual, and if you're doing broker load, it's even more important because the broker load people do it on their own, and they're supposed to send it to the office. They send it to new.listings at central21.ca, and Anna sends it to me DocuSign. Please don't send your DocuSign directly to me. It just holds everything down. I get all kinds of different DocuSigns from different realtors. You guys use all kinds of AuthentiSign, DocuSign. There's a couple more out there. PDS, Adobe Sign, and all this stuff. I don't know what you're sending. So it's going to slow it all down. I don't know what the hell it is. I know where it's coming from. And a lot of times, even developers will send me stuff directly because you'll give them my information. I don't even know who the developers are. And I get this, thing to sign this thing. Well, I'm not signing nothing. I'm a managing broker. My liabilities are so high, guys, that I have to be very, very careful what I say, what I do. And anything I sign is very important. So have it come through the office. That's the way it works. The same for our property manager contracts that come through the office. They're vetted through the office. Make sure they're all done correctly. Go to Mike for signatures and so on and so forth. So we kind of have a system in the office that works. Please try and utilize that because it's for a reason. We track everything and watch everything going forward there.
Why can't I need more checks this time?
Yeah.
You can send
Is
those.
that what those were? I kept signing those things, they kept coming, and it was just more and more and more. Fintrac. Scary thing. We're all doing the right thing. We're not cops, but they want us to be cops, and they put all the responsibility on the managing broker. If there's any, compliance issues with Fintrac. So please fill in those forms as clean as you can. If they're retired, what were they retired as? Were they a retired teacher? Were they, a retired accountant, whatever they were? We've had some that were multi-billionaires, entrepreneurs. I said, well, put entrepreneur and what kind of business they were doing there. Put something in there. And if you asked and they said, nothing, I asked and they said nothing. As long as we have something there, as far as I'm concerned, we've done our due diligence, we've done our job, but please put something there. Don't just leave it blank because we have something to back up on that one there. Got that. If your subjects expire and you've got an offer in and the subjects expire and it's not signed by everybody, the contract's dead. Ken Spence used to call them zombie contracts. So, and he'll always call me, well, it's only a minute after yeah. Doesn't matter. It's a dead contract. If the subject expires, done. But the good thing about that is if you've been through all of that and you're on the last little bit here and you're just ready to remove subjects and you didn't do it in the proper time, what you can do normally is write up a new contract with those subjects. And just put that one in, submit that, and everybody signs, and then you've got a valid binding contract, because you don't want to get to the end of the road here and find out you don't have a binding contract. That's the scary part. And that's why I go with the rescission period, fill all that in, make sure that's all in the contracts. Your contracts are complete. Our job is to write binding contracts. And if we leave them blank, that leaves it open for interpretation. If a lawyer or one of the parties wants to get out of it, and they were to take it to court, we don't know what's going to happen. Ken will never tell you yes or no, but it may or may not cause, some complications and unintended consequences for that contract going forward. So just be careful about that. Make sure it's all filled in. Make sure your initials are all there. Make sure PDS is done correctly and it's included with the contract if you can. And if your subjects do expire, the contract's dead. Rewrite it. For the PDS, we talked a little bit about that a couple of weeks ago. We had that on one of our meetings. There's a new form now. You don't cross out the PDS anymore and decide if it was a rental or if it was an executive will or whatever it is. There's a no disclosure form now. So it's an actual form that says there is, we're not disclosing anything because we don't know anything. And it's a legal form that's been put out by the board and it's in your web forms. So if your client wants to cross it out, no need to anymore. Fill out that form and that's in place of crossing it out because apparently, go ahead.
Oh, no, finish your thought. I will see.
Yeah, because apparently what happened at one time or another is that somebody crossed it out and it went to court and the seller lost. because they ought to have known or whatever it was, the judge decided on that one. So now we have the no disclosure form.
My question is, are sellers who are owner occupied, are they allowed to use that if they just don't feel like disclosing? Cause I just ran into that.
Owners that are what?
An owner occupied property. My buyers wanted to potentially offer on it, and they owner occupied, but they had a property non-disclosure because they didn't feel like one.
Do they have to disclose to us if they're not?
Yeah, but,
So even if we don't know that there's levy ID.
yeah, no, I know, but they use the property non-disclosure.
That's.
Yeah,
that's-
like, I was like, I don't think, my clients back today, they're like,
Yeah, that's weird.
Well,
Like a seller.
you think?
Well, you think, yeah, but I mean, you can put in your contract, subject to, PDS.
Yes, yeah,
You know, and put that as a subject, and if they don't do it, then you've got an argument point back and forth.
yeah.
Why don't you want it?
It took the confidence away from my buyers. They're like, no, I'm not.
Well, so it should, yeah.
Yeah,
Bad seller.
yeah, exactly, exactly. I just thought that was weird. I was like, you're allowed to use it if you're.
Yeah, it should-
Obviously, that means don't tell people, yeah, you do, not in, if you use that form, you don't. Against the law, right?
that's right. So it's either a PDS or that one, but it's not meant,
Yeah, I didn't think so.
it's more meant for executive of the will,
Yeah,
you know, that kind of thing, yeah, rentals, that kind of thing going forward. That's all I got here, Ken's gonna be along talking about.
A couple more things.
Yeah,
Sorry.
sure, you go ahead.
So guys, you got, thanks Doug. Good job. Good job. We sent out an email to you all regarding a new outline for our team meetings, because we gotta spice it up, we gotta bring in guest speakers like Ken. Doug's got some good topics, but I asked you guys if you wanna be a speaker on a bunch of different topics that happen to us every day. How to combat difficult buyer, difficult seller, difficult realtor on the other side, objections in the market slow, I'm gonna wait, all this kind of stuff. So read the email that I sent. And if you wanna stand up here and talk to your fellow team, I would love for you guys to do that, because there's no better person, in my opinion, than you guys doing that for us, right? And I can do a majority of them as well, but I love to hear from you guys. And so read the email. I'll send it out again for those of you that need me to send the emails a couple times, and it's in our WhatsApp. Was it?
It's not under
Well,
WhatsApp.
we're gonna put it in.
Wait, I'll put it in.
Okay, thanks. And so, and that's gonna start from October going to the end of the year. And then we're gonna bring in some guest speakers as well, the accountants, the lawyers, the estate planners and stuff like that, just so we're all prepared. Paul, money man, get your butt up here. Give us the crystal ball prediction of what you think the rates are gonna do and why.
don't do it.
Let's make mortgages fun, eh?
No.
Thanks for having me, everybody. There's a few faces in here I haven't really met yet. So first and foremost, I'd appreciate it if we can get some time together and sit down, have a coffee and talk about how I might be able to help the clients. It's an interesting market right now. So Doug mentioned pre-approvals. I'll start on that. It's very important. There's a big difference between a bank pre-approval and what we look at and what we underwrite before we tell a client they can go shopping. My number one goal is let me see all the documents up front before you write the offer. That's always what we want to do, so that somebody doesn't write an offer, fall in love with the house, and then find out there's financing issues. We want to avoid that for everyone's sake. Outside of that, I mean, yeah, full underwriting on our side. By me, number one, I was a lender a long time ago before I was a mortgage broker, so I'm capable to understand. But 100% certainly pretty much if the lender's going to do the file. There are some tricky files out there that might take a bit more time, but generally we'll have a good idea. And then the lender obviously has a second look at it. So if there's an issue that we see before the offer is written, we communicate, we talk about it, we manage expectations. We ask for extra time, whatever it takes to get the deal done. So the client has a stress-free experience. That's what it's all about. Interest rates. Should be some good news tomorrow. We're expecting a 25 basis point decrease. I'd be surprised to see 50, but you never know. Inflation did come up a bit this morning in the month of August, but there are many other factors out there that are saying we should see a rate drop. People need to save money in Canada, the government understands that. Bank of Canada should understand that too. So I'll be letting everyone know bright and early. I'll try and beat people before they wake up and see it themselves. But we should see a drop tomorrow morning, so that should be great for consumer confidence. It should be great for your clients on lines of credit or variable rate mortgages. And the bond yields have been dropping for the last week and a half, so fixed rates are coming down. We do have access to 5-year money sub 4%, which we haven't seen in a while. Most of that is insured, but we do have a conventional quick close that's 3.99. So lots of options there. Under 4% are great rates. We're not going to see 2 or 3 for a long time if we ever do again. So very affordable for clients. I wanted to touch a little bit on pre-sales. Like mentioned, it's a little bit ugly. I'm doing a lot of work on trying to save pre-sale closings, right? There are all those other options out there outside of banks. If clients have a little bit of equity, maybe a bit more than the bank would want, and they've got some outside properties. If they are up against losing a large deposit, we do have ways to finance to complete on that so they can be listed. So if you have any questions about that, always give me a call. There's a lot of private money out there. They are strong trying to get pre-sales built. Okay? Short-term stuff, it is expensive. And if you're going to lose a $200,000 deposit, you might want to then close it and try and sell it quickly or rent it out if the market rents are high. I think that's about it for me. I mean, we can talk about all sorts of mortgage products, but we don't need to do that today.
Any questions?
Does anyone have questions about anything?
Yeah, I was just thinking of, I thought that, you could take out for first-time buyers, cars, these 35,000, and now it's gone to 60.
I thought it was 35 per person, but I could check when it went up to 60. I haven't had one of those in a while, so like the last time I checked it was 35 per person.
Okay, so I've heard it's like 60 per person.
I will find out sure.
I'm really confused.
Yeah, I'll check. I'll put it in the WhatsApp group so we know how to answer.
You mentioned that your pre-approval process is different than the bank's pre-approval process, and that can impact the deal later on. Could you just explain that a little bit?
I can. Often when a person walks into their bank that they've been banking at for 30 years, the frontline people are very inexperienced. They don't really know what they're talking about. They don't have the time to send. If you want to talk about a mortgage when you walk into a bank, you probably need to go up 3 or 4 levels. Talk to somebody that knows what they're doing. They are trained and probably have a very general algorithm in there. In most banks on what, based on the income that we knew of 5 years ago, 10 years ago, without updating the credit bureau, you look like this will work out, go ahead and make an offer, you'll be fine. So it happens a lot, and the client trusts the bank that they've been with for a long time. And then once they dig into it, things change. So hopefully that answers your question. Yep. Awesome. What? More.
Can I have some money?
I have an application link
All right.
later today.
Thanks, buddy.
All right, thank you, everyone.
We've got, and Ken is here, but just before that, we have a field trip this Friday. Up by Nat Bailey Stadium, Holborn Properties. Very good developer in the marketplace has invited us to go see their development project. We're one of the first to go in. You can't bring your buyers in, it's not to market yet. But this is what I'm hoping for when the market changes. We get good developers that want to hang out with good brokers, good realtors. So Sharon Matsumoto, good friend of ours, has organized that. So I would love to see that whole room full. I saw it last week. It's beautiful. It's well laid out. Price point, I believe it's very fair in the marketplace, and it's got everything there. It's going to be its own community. So make sure Friday. What time is it? We're there 2 or 3. 2 o'clock. It's 2 to 4. 2 to 4. There's going to be snacks. There's going to be a door prize. Don't know what the door prize is, but these guys are usually pretty good with all that. So please make that note in your calendar. We'll send out the reminder again. Our good friend Ken Pazder is here with Melissa, right?
Yeah.
And Ken is, in my opinion, best real estate lawyer in the marketplace. So The notaries are the lawyers, use the lawyers every day. And Paul had best mortgage broker in the marketplace. If your client's been pre-approved with the bank, ask them if there's an opportunity to save them money, because I know Paul in a meeting. And you're the hero, because if Paul can beat the rate, you're the hero. And if they got the best rate in the marketplace, then they're eased down. That's another thing off their back. So Ken, come on in.
Okay,
Good to see you, bud.
nice to see you.
You gotta stand right over here.
Okay, so this is my associate Melissa. She's actually been with us 6 years now. So if you call our office. Good knowledgeable about real estate. She's done now hundreds and hundreds and hundreds of files. So Doug came up with some questions for us, and apparently that some of you guys have had over the years or over the summer. And so we'll just talk to you guys about this stuff, and if you guys have any questions, just stop us as we go. And we'll go from there. So one of the first issues was powers of attorney. So does anyone have a power of attorney for someone else? Has anyone seen a power of attorney?
Yep.
Okay, so power of attorney is something you guys will run across once in a while. You run across them all the time. So there's general powers of attorney and there's specific powers of attorney. So specific power of attorney just means you can do one thing for me. So you can do my bank, you can sell my house, or you can set up an account for me. Then there's a general power of attorney, which says you can do anything for me. Anything that an attorney can do, you can do for me. So that's all legal stuff. Yeah, that's got nothing to do with healthcare. It's got nothing to do with moving mom into a nursing home or consenting to a medical treatment. That's a representation agreement, which is covered by something else. But a power of attorney from you guys' point of view is someone would say, well, I want to sell my mom's house, or I want to sell something on behalf of someone else, or mortgage something. So there's two other categories of power of attorney. There's enduring power of attorney and there's non-enduring power of attorney. Okay, so anybody know the difference?
Enduring just means that it continues on, and then the other one has a specific date by which it ends by.
Yes and no. The enduring power of attorney, generally the law is if you lose mental capacity, your power of attorney is done. Okay, so if you die, your power of attorney is done, but if you lose mental capacity, you can't instruct the attorney anymore, so it's gone. So enduring power of attorney is specifically designed so does not happen. So if your mom or your dad is older and they're kind of having some illnesses, you get an enduring power of attorney. So if they lose mental capacity, you can still carry on acting for them. Okay, so you can continue acting till they're dead, and then the power of attorney stops. So if any of you are older parents and they say, do a power of attorney so that you can help me with my banking or help me with stuff, make sure it's enduring. Okay, because yes. No power of attorney continues after you're done. But the point is, if people are older, like parents, that's the time you want to get the enduring power of attorney. So you generally make it in general power of attorney, so you can do anything for your parents, including their banking or sell their house or do whatever is necessary. So remember, a power of attorney, you have to act in the donor's best interest. You can't just do stuff because it benefits you. You have to do stuff that benefits the donor, which in this case would be your parents if that was the case. Most powers of attorney do not let you transfer stuff to yourself. Okay, so I'm the attorney, I can't transfer mom's house to me. Okay, unless it says that. If it says it in the power of attorney, you can do it. If otherwise, you can transfer it to someone else and give the money to mom, and maybe she's going to go in a nursing home. So the bottom line is, so for you guys, you say, okay, this is all nice, but how will this affect us? So some guy comes to you and says, I want to sell my mom's house because she's in a nursing home, and here's a power of attorney. So what's the first thing you do at that point?
Read it.
Read it, yes, and see if it does what you think it's going to. So first of all, you're going to see, just say enduring on the top, because if it's not enduring, it's more than 3 years old, land titles won't take it. Okay, land titles just has this little thing that says, well, after 3 years, we will consider a regular power of attorney. We're not going to accept it. Unless, of course, there's a clause exempting that. So you read it, and my suggestion would be to send it to us, and so we'll read it and make sure that whatever you want to do with it works. Okay, so can you do what you think you're going to do? And then we'll have to file it. If it's not filed at land titles, they won't take it. So you need the original to file. You cannot use a certified copy. You cannot use a copy. It has to be original.
Here, so
One of the biggest things for land titles is they want to see that power of attorney is valid and properly prepared. So that's why it's always a good idea to send it to us first, so we can have a quick overview. Land titles has been defecting power as an attorney left, right, and center for us. So they are sticklers to making sure everything is properly prepared in that power of attorney. And like Ken said, we need to have the original session in order to file it. You cannot your attorney cannot sign any land title documents unless it's filed at land title's office. And it's just one of those things that even if it is filed, when we go to file Form A transfer, they can still defect it at that time. So go ahead.
Is there a stamp on it that says it's filed?
Yeah, typically in the right-hand corner, it'll say there's registration number and filed at land title's office. That's okay.
And percent now if you're on the time. So let's say we know power of attorney, grandma's got 5 years left.
Yeah.
Should they put the name of the power of attorney on the title?
Yeah.
You can't do that.
No, but you can search the land titles office for filed powers of attorney. So if we know the person's name, we can run through land titles and see if there is a filed power of attorney for that attorney.
And those enduring that are specific to real estate, need to be done every 3 years.
No, if it's enduring, there's no limit. So
So-
it's only a non-enduring power of attorney is good for 3 years for land titles purposes. The enduring power of attorney lasts until the person dies.
And can you speak briefly about prepared properly?
So there is a whole power of attorney legislation, all that is prepared and witnessed properly. And so land titles really looks at the format, make sure everything, the witness address, everything is in there specifically. The non-enduring powers of attorney, they, for example, such a power of attorney, for example, in the event of somebody becoming incapacitated. Typically in the attorney will say, you can use this power of attorney if 2 doctors have confirmed that I'm no longer mentally capable to handle my own legal affairs. Land titles will want to see the evidence from the 2 doctors that says they are no longer capable of handling.
Yeah.
So that's why it's always good just to send it to us so we can have a quick overview to see if that.
So one other thing is when someone wants to use a power of attorney, your default is always, well, why don't we have the real person sign? Like why did mom owns the property? Why can't mom sign? So you want to do some investigation to at least find out, hey, mom is around, mom's a real person, mom's in a nursing home, maybe check what nursing home it is, phone up the nursing home, make sure she's there. I mean, sometimes people are in pretty rough shape, so, you know, they're not gonna be able to communicate with you directly, but certainly talk to your person who's hiring you and say, okay, why are you using this power of attorney? Where is your mom? You should be able to tell me. She's in that nursing home over there. You could phone up and find out that she's there. So I'm just saying, there's potential for fraud, there's potential for abuse. Which is why they changed the Power of Attorney Act 10 years ago and made this enduring power of attorney a big deal. It's more difficult to get it signed up, and there's more rules and regulations for someone that has an enduring power of attorney. You have to report all the transactions, keep the receipts, everything like that. Because you could be called into question later by somebody else who says you misuse this power of attorney. So for you guys as agents, if you're having someone that's going to hire you as an attorney for somebody else, and do some due diligence, find out where that person is, who they are, what the relationship is, and why they can't sign. Okay, and there can be good reasons, but other times there's not. So it's just something to be, red flag goes up, power of attorney. That's what the bank says right off the bat. So the title insurance company, why is this guy using a power of attorney? Okay, so there's good reason, fine.
Yeah, title insurance it's a flag for them. If there's a power of attorney involved, they want to know. Powers of attorney are often used in fraud cases, so be extra cautious if you're using a power of attorney, like Ed said, ask why. If the person's just like, oh, well, I don't feel like coming to the office, it's probably not a good enough reason.
And if that's the case, then we'll talk to the person who's actually doesn't want to come into the office and have a chat with them.
Yeah.
Okay, because again, people are trying to do a fraud or do something untoward. They don't like investigations. They don't like throwing information on the table. Well, go ahead, phone them. Yes.
I'm not on the buyer side, because I see quite often listings that there's a POA, that the city is doing this. Do we need to take the extra step on the buyer side?
If the seller is selling by POA, well, again, same thing, the lawyers will do some of that because we will check to see that the power of attorney is registered. So I don't think you have to do a lot of checking when you're on the buy side. If you're using a power of attorney, your client's using power of attorney, that's where you want to check. But for us, we'd check, we'd get a copy of the power of attorney, have a look at it. And then we would probably title it to the file. So, yeah. Exactly. So the other tricky thing, just so you know, if we were to check and say this power of attorney is already registered last year, we still want to look at it. Because with land titles, they're very schizophrenic. Sometimes they are a court of law and they rule on all kinds of legal issues. And other times you go, you know what, we're just a registry, just put the stamp on, we're good. So to file it, as long as you dot all the i's and cross the t's, they'll stamp it and it's filed. But then you go to use it and they go, oh, you can't do that. This paragraph says 6, you're doing something. Nope, we're not gonna let you do it. So sometimes they play like they're court and sometimes they play like they're registered. So just because it's filed, you still want to look at it. Okay, because you have to say, well, this is what we want to do. Does this power of attorney let us do? If land titles doesn't think so, then you have a problem. They'll defect the whole transaction after the fact. So everything gets registered, the guy moves in the house, money changes hands, the mortgage is on the title. Guess what? Power of attorney was no good, title didn't transfer, and the whole thing's shot. And it's a big mess. Okay, so that's powers of attorney. Just, you may not run into them maybe once every 5 years, but if you do and you have any questions, feel free to call us. You want to talk about remote signing, Mel?
Yeah, remote signing also akin to powers of attorney. Exercise caution when you have a remote client. Make sure you verify their ID and source of funds. That's a big one. There seems to be some misconception that remote clients can sign land titles forms digitally. That is not the case. They still have to go see it or come in and see us. And one big thing too, if you're acting for a buyer who is not located here in Canada, some lenders do not allow their documents to be signed outside of Canada. So that could be a big thing financially for them. To name two is TD and First National do not allow their documents to be signed outside of Canada. So that could affect their financing. But always exercise caution when you don't see your client. If they're not in Canada, typically what will happen is they have to go see a notary or wherever they're located, and we'll send them the documents with instructions, and they can be verified their ID then. But definitely exercise caution because again, fraudulent cases happen when you don't see your client in person and you don't get those instructions face to face.
And so again, just so you know, probably everyone knows by now, with COVID being gone, there's no remote signing. We can't do Zoom signups with clients anymore. We can't do DocuSign. So you guys DocuSign all your contracts now, or at least most of them. We see, but we can't do that. Your clients can't do that for us either. So we can't send the documents to clients, say, here, DocuSign this, that, the other thing. We can the odd thing, but not the stuff for land titles.
I have a question. If it's vice versa, basically a client that you already know everything, but moved overseas. So he still has a property with intention of selling. Do they have to come back and sign all the paperwork in that case?
No, you can sign anywhere. You can sign in any country in the world as long as there's a notary there or Canadian.
Okay.
I would say Canadian embassy, but Canadian embassies now have gotten so bad after COVID. You should be able to take documents in there as a Canadian citizen and they would sign them all now. They're kind of really hit and miss. But fortunately, there's notaries everywhere.
Yeah.
So like
Okay.
right through the United States, they're in the banks, they're in the Walmart, they're all over the place. So again, depending, US is not a problem. Mexico is a big problem. South America is a big problem. Europe is a big problem. Notaries there may charge your client a couple of $1,000 to notarize.
Not only, it's a different kind of, for instance, in my case, I'm talking about Italy. Notary, it's really bad, meaning that the notary has really a lot of power and they charge thousands of dollars.
Yeah, well, see, notaries out there, it's a whole different thing than the notaries here. So there's 3 types of notaries. There's the notaries in everywhere, like the US and all, and most of Canada. They just notarize documents. That's all they do, and witness stuff. And then there's the notaries here who can actually do a land deal. They can do a mortgage, they can do a purchase, they can do a sale, and they can do some wills, which is unusual. This is quite unusual for notaries here. And then there's the notaries you're talking about in Europe who have this extraordinary amount of power and they can charge whatever they want.
Yeah,
And it's very hard to be a notary. So again, if you're in Europe, yeah, you'll just go see the notary. Well, maybe not so much.
And
Think
I
about-
would just qualify that, it should be an English speaking notary, because land titles
That's
does
another
not allow their
problem.
documents to be translated and then translated back. So it should be an English speaking.
So again, if you're.
most likely it's cheaper for them to come and sign everything.
More
Exactly, so yes. London, we've had a client sign in London and they have come back properly. So,
Yeah, it should indeed.
Yeah, Hong Kong, not bad, Singapore, not bad, because a lot of big law firms have offices there, so there's lawyers there. The interesting thing about lawyers and notaries is the Evidence Act in BC says a notary anywhere in the world can witness the documents. The lawyer, sort of, yes, some no. Anywhere in Canada, no problem. Outside of Canada, they have to be an officer of the court. And some jurisdictions they are, some they aren't. If they're not, then they can't witness documents outside of Canada. So again, it's just check with us first. If you say, well, the client's going to Holland, maybe the client leaves a power of attorney with you first. And then you can sign everything. Or maybe they may, in some cases, we can get the client to sign before they go. But if not, then you've got to find out where they're going and is it going to be a problem for them to see someone and track someone down.
How soon before a sale or whatever, can they come in to see you to sign all the documents? Be 2, 3, 4 weeks?
No, see, the problem is on whether it's a sale or a purchase, the documents tend to get prepared in the last 2 weeks. Okay, so if you're buying, you're not gonna get mortgage instructions from the bank for at least a week before if you're
is
lucky.
that, yeah.
So the guy
They
can't.
send out blank documents there?
So with the electronic stuff, we can't do that anymore. We used to be able to sign a blank transfer and they, just fill it in later. Can't do that now. So yeah, just everything's gone electronic. It's got all timestamps on it. We can't fill it in later.
And sale files are probably the worst for that because buyer's lawyer prepares all the documents, the seller's going to be signing, so you're at the mercy of the other legal representative. And if they want to cooperate with you, great. If they don't have to. So sometimes we get them the day before closing, 2 days before closing, and we're kind of at their mercy.
Okay, so what else? Okay, just one last just one thing I'll tell you, try to not do a same day closing. On purpose. Because we see that a lot out of White Rock for some reason, there's kind of those out there. And the reason it's difficult is because this province is really kind of backwards in terms of real estate. As Mel said, the buyer's lawyer does all the documents. They do the seller's documents, they do the buyer's documents. So why? Why doesn't the seller do their own documents? Who knows? This is a crazy province. So the other thing that's crazy is when you buy a property here on the closing date, the seller, us, for example, we have to go get the money from the buyer by the close of business. So the buyer can phone us literally at 10 to 5 and say, we're good to go. Here's your money. Well, we're in Maple Ridge. Okay, well, you can get it tomorrow then. So that's how it works here. So the trouble is, if you're using that money to make a purchase on the same day, the other guy phones you from Maple Ridge at 5 to 5 and says, we have your sale proceeds. You're not going to be able to use them to close the purchase.
And if you have one of these B type lenders, that may screw your financing for the day and your whole purchase is just screwed up. So, and getting financing and having to re-request funds and everything is a process, so please don't do same day proceeds.
Just one purchase, having the, we should have.
No, if you're sale.
Sell and purchase on the same.
Selling and buying.
Yeah, both closing on the same day.
Yeah.
And so the only way to fix that is to have interim financing, so that you can go to the bank and say, I got the money, even if we don't close, I'll borrow the money for a day.
Are we ever gonna get on board with e-transferring? these
No.
funds? No, I just don't get that.
No. There's too many issues for lawyers. We can e-transfer, but no one does, like virtually no one does, because it's such a pain in the neck. So. What's that?
Is it you?
Well, there's a limit on e-transfers.
Maybe you think it'd be like
Yeah, there's also a lag time, so sometimes you transfer, it gets there in an hour, sometimes it gets there in a day. So it's really, it's, I think, you know, at some point, these cryptocurrencies like XRP will fix that, where it'll transfer in about 10 seconds. But now it can be a couple hours, it can be a day. So say, well, we paid you, but hasn't showed up in the other lawyer's trust account. So anyway, just wherever possible, try not to do a same day closing where the sale and the purchase close one day apart, no problem. But same day, that can be difficult. And if you get a jerk on the other side who doesn't want to give you an extension, then that means your buyer will go into default because he doesn't have the money to close. Trust me, there are some jerks out there.
I know.
It was stupid.
Yeah, so you say, and even though lawyers and notaries, they cooperate quite a bit, they try to say, okay, I know you have a same day closing, we'll deposit for you. We're in Maple Ridge, we'll go to CIBC and we'll put it in your bank account in Maple Ridge. But what if they don't have time to do that? What if they're short staffed? What if they got their money really late in the day? As Mel said, they're dealing with a B lender who funds late in the day. Well, guess what? It's beyond that guy's control to help them. So anyway, just don't put yourself in that position with your clients because it'd be very hard to explain to them later why they defaulted on their purchase.
Not only that, it could be a complete domino effect, because then that person who's selling could screw up their scale, they're buying something else that screws it up for them, it's a complete domino. So. Yeah.
Okay, now you want to do this one, says parents buying for kids. So sometimes
Yeah.
parents help out kids. As you guys probably know, if your parents don't help, you're probably kids not buying any.
No, and one big thing when parents are helping out kids, source of funds. Still have to identify where the parents got money from in order to help out their kids. Some lenders will require parents to go on title, others will not. So I always recommend put that clause in your contract that says the buyer could add a party parent before closing. One thing I will bring up, one of my biggest pet peeves, if I see the line in the contract that says buyer may add so-and-so, does not mean they are adding so-and-so. You still have to do an addendum later to say they're actually adding those people. Cause that screws up so many closings when we get documents on the sale side and there's different buyers on the Form A transfer. And who are these people? Yes, you had the right to assign it, but we have no evidence that you actually did.
Yeah, so again, when you're adding people to a title or you're adding people to a contract, there's only two ways to do it. You do it by way of assignment. You assign the contract from yourself to yourself and that other person. Or you do an addendum and everybody signs the addendum, which includes the new guy, the seller, and the buyer.
Yeah.
So there's two ways to do it, but you have to do something. You can't just say, I have the right to add this guy, and at the last minute, I just put him on the paperwork.
One of the clauses that somehow at the buyer without need the permission of the seller. How does that work?
Same thing.
You just
You're
do
gonna
an addendum and you sign it.
Yeah, you still need to do an addendum. What I find, you can't have the seller and the buyer sign the addendum, the seller, the buyer, and the new guy signs the addendum.
Yeah.
Okay, so it's like, I can't put, me and Mel have a contract, I can't put you on the contract without you signing it. Right, so guess what, you're a buyer now, you're not even involved in the contract. So you sign the addendum saying, yes, I agree to be a buyer.
I'm about to face this actually soon, where the parents are gonna transfer the money to my client's purchase, so that goes from the bank. No mortgage, it'll be a straight cash, so it'll be like 1.7, it's a lot of money. This is it's not gonna be a mortgage, so when you say like, lenders obviously want. Different, but I was actually talking to Doug, and they recommend just getting a letter of credit. So. Verifying your ID, and it's just.
They're the third party, actually.
They're kind of, yeah.
And how do we deal with that? It's 100%, no mortgage, no nothing. Parents are giving them the whole 100% of the money.
Yeah.
How do we deal with it?
Like, if you never told me that, I would just assume cash. I'm told.
But you see, for us now, I don't know what you guys do, when somebody makes a deposit, your Fintrac stuff, do you have to ask them where this money came from?
No.
Somebody puts $100,000 into your trust account to, as a.
Well, yeah, for the 100,000, but the kids are coming now, 1.7 million is coming. That's one of that, that's going to the lawyer.
Yeah.
Go into the
He's getting the
purchase.
Right, but then that won't go through your trust, right? So that's the lawyer's problem to figure out where that money came from.
Yeah, but I'm kind of leery about that. Should we not do something to preempt any problems?
Oh, you could, but like I said, the lawyer can't just take that 1.7 million and say, okay, it's all good to go.
Yeah. But would that be a third party buying it because they're buying it? They're putting the money out, not the kids.
Who's going on title?
The kids are.
Okay, so there's two things can happen there. If you have the parents putting in the money,
That's right, guys, we'll get one conversation here.
no worries. So if the parents are putting in the money, there's only two things can happen. Parents go on the title with the kids or they don't. So if they don't, is it a true gift? So I've given my kid $1.7 million. He is the real owner of the property. Or is the kid holding it in trust for me? So is there like an unregistered trust agreement saying the parents really own it, but we're just putting the kids on the title for whatever, maybe for first time buyer
What I
purpose.
know is could be hills.
Right.
But it comes out of his account. It's gonna come out of his account. Why did you know that?
So
Unless he did. Yeah.
So it's important to flush that out with the kids when they come in, because you say, well, like, you really own this is a gift. So, it's your parent gifted it, and then the problem becomes, is it a gift and from whom? Because usually it's a couple, it's not just one kid, usually goes on the title, he's married, he's got a girlfriend. And so now, like, two kids are on the title, where'd the money come from? Well, it came from the wife or the girlfriend's parents. Okay, so under the Family Law Act of BC, that gift is exempt. It is an exempt transaction, so they split up 6 months from now, the other party's getting nothing. Okay, so it's important when you get these gifts or a gift letter, for example, whose daughter is it, whose son is it? That's where the gift is going. And if you give a gift to both of them, you've just given away half the money.
It's just him on his own.
So the other thing parents do is they can put a mortgage back. So in your case, the parents could put a $1.7 million mortgage on the property for the next 5 years, no interest, no payments. And if they split up, then they just give them property.
Yeah, Ken, I think the thing that I'm more worried about is the money laundering. Like, what if it isn't the parents? What if it's coming from something else?
Exactly.
And that's, where do we sit on that one? If we got a letter of credit from the bank, at least we got a bank in there that's kind of exonerating.
Yeah.
We've kind of done our due diligence relative to flushing out where this money's coming from, because we don't, these people, I mean, we don't, often.
Look, I'm gonna FaceTime with parents. Beat them that, because they're in California. And get them to show them FaceTime, then I can add that to the Fintrac.
Well, presumably that they're not gonna come with a bag of cash. They're gonna send it by a wire transfer
Yeah.
or a bank draft
Yeah,
or
it's gonna go
something.
into the son's account. We're doing
Be like,
it.
That's-
I want it.
Bag of cash.
Yeah.
Yeah.
So in this situation, so first, the dad's told, on completion, the son's paying for it.
The son's
You
paying.
don't need a gift letter, 'cause it's not going to find, is that
Yeah.
right? You don't need a gift letter?
No.
Because if, let's say he was giving $1 million for this, not 7.
Yeah, that'd be good.
The bank requires a gift letter, and they also require it to be paid in account for
Yeah.
90 days, is that
Yeah,
right? 90
yeah.
days.
But
Okay,
there's no bank or
so
that.
in your situation, there's no
Yeah.
gift letter required,
Yeah.
and do you need a fin check on the dad?
Well, that's what I was trying to think about.
Do you need a fin check on the dad?
I don't know, because we don't deal with Fintrac, lawyers are exempt from Fintrac, so.
My God.
I know that's what I'm looking at, but,
They're exempt?
Still,
I mean, it's all on video.
The first time I hear this.
Yeah.
Well, I asked for something.
So among all the categories.
Yeah, that's what I was
that
gonna
this
ask.
would be the-
So try to show our due diligence.
So we're like,
That's what I'm asking.
it's basically done for now.
Like, where's that paper trail, where you got this from?
I think they're probably. Kind of a pre. That's enough, yeah.
Like, I liquidated some stocks, okay?
Yeah.
Can you show me something that's what you liquidated?
Yeah.
Well, that's what we're asking for letter of credit.
Yeah, so all you're doing is some due diligence to say, where did this money come from? Give me some legitimate source
Yeah.
as opposed to its judgment.
Yeah, that's.
What we have the same problem.
Bank, client, if the bank can get a letter from the bank,
Yeah, the parents.
Say they're good for the money.
the parents' bank.
Yeah, from it's going into his. Yeah. We need to verify the source. We want to get a letter of credit from the parents bank just to show that they actually have that money in.
And all they, and could they just do deed of gift?
They could do that if they wanted, or they could even give you the contact information from the bank and say, I will give you permission to talk to my bank.
Yeah.
You
That's
can
all
get
it
it
is,
right from, put a note in your file, I talked to so-and-so at Royal Bank and
Yeah.
such and such day, they confirmed the money is here, this is where it came from, we're good.
Yeah.
So just to really, if Fintrac comes along and audits your file, and you say, okay, this is the due diligence, I get, that's all it comes down
Yeah,
to.
that's all around.
Just had a question. I was going to clarify that you stated the portion that would go for the sale at the end would be on the lawyer to verify, because I had a recent transaction like that, which was completed yesterday. The money was coming from Korea from the family. But then I only did the Fintrac for the deposit that I got from the client.
Right.
The money that would go for the purchase is on the lawyer to
That's
verify
right.
that, right? We're not gonna be.
That's right.
We just wanted to clarify.
So we're in a kind of a gray area because we're exempt from Fintrac. We still make some investigations. So again, if somebody's buying a house and they're 45 years old and they bring in 300 grand and they say, well, it's from savings, okay, fine. The other hand, the kid's 21 years old and he's buying $7 million house in West Van cash. Now, you gotta do some investigation. Because there is a lot of money laundering, there is a lot of clandestine money that comes in and out of real estate. So when the person's circumstances and their age and whatnot doesn't fit what they're buying, then you have to do something else. Generally, if they are a crook, they're just gonna disappear. Now, what's the next one?
Just one more thing too, if it's a loan. And which in your case, it's not, but if it is, and they want a mortgage secured against the title, and they want that mortgage secured on. See, parents need their own legal rights. You can't add for both kids and. Exactly. So they'll have to get their own documents.
Yeah.
I'm just confused, so if they're giving them the money, they will mortgage, away.
So if it's a loan from the parents and they wanna put a mortgage on that title at the time of closing, like you would do a regular bank, it's just mom and dad securing a mortgage
So
instead.
mom and dad's the bank.
Yeah, so mom and dad need their own legal representative. You can't act for both. Okay.
Yeah, my understanding is it's just getting wire transfer to,
Okay.
like a kid.
Yeah, absolutely. Okay.
What's the next one? No, you're not. Okay.
Foreign buyers then.
Foreign buyers.
Hey, guys.
You guys know there's still a foreign buyers ban out there?
Yeah.
Sorry, what did you say?
2027.
Buyer's banks. January 27th. Have they been talking about it?
Yeah. They've been talking about maybe getting rid of it, but I don't know whether it's fine, well or not, since I don't think it cares too much about real estate. So the bottom line is the foreign buyers ban is there. There are some exemptions, you know, you can have spouses, Canadian resident or permanent. Or citizen of Canada, and then they're exempt, both of them are exempt. There's other exemptions, you know, for.
Yeah, this area is that I was talking to Ken on the right here, is a complete one. Because even if you can bypass the ban, you're probably gonna get hit with more fines. So they have exemptions in this area, for like work permits, temporary residence, specific, that's some use and whatnot. But yeah, even if you can bypass the first one, you're probably gonna get hit with the second one with the tax. So just be mindful of that if you do have a foreign buyer that you're with. So one of the exemptions is foreign buyers can buy if their spouse is also going on title and they're Canadian. But again, that spouse is likely gonna get hit with the tax.
Yeah.
And one question we always get is, can I put my spouse on for 1% for 99? That is now a very gray area. Because property transfer tax department has now audited a lot of those files, saying there was no legitimate excuse for one of the spouses to go on for 1% other than tax avoidance. So you can no longer default to that. If you're putting in half the money, then yeah, great, you can go on 50. You should be going on 50-50. If you're only putting in 1%, then you have a legitimate excuse to go 99-1. So just be mindful of that. There is a huge tax consequence with more clients.
I have other clients that are trying to look through the gray area, and I've talked to the Campbells in Florida, they're movie producers. They don't wanna be involved with Trump, and they wanna move here, and they make movies here all the time, employing Canadians, paying Canadian taxes, but they're fully. And I was trying to search like what the exemption could be, because they wanna buy a house. they employ thousands of people every time they make food. But they're Americans, so there's, like, I couldn't find any literature on.
Yeah, well, again, they probably wouldn't have a temporary work permit because they're basically self-employed.
Yeah,
assuming.
self-employed.
So they're that one, they're not a foreign student, they're not Canadian citizen, they're not a permanent resident, they're not gonna buy. But now, if they wanna buy it in sticks, that's fine. This foreign buyers ban really just applies to municipal areas. So they wanna buy out in the middle of nowhere, that's usually good. They can usually buy a farm, that's fine. But if people wanna buy in like where you guys sell, which is kind of Metro Vancouver, well, that's gonna be a no.
Because agriculture is.
Yeah, agricultural land is exempt, which is too bad, because of course, all China is buying up all the farms, so not a good thing, but again, it's just a different version. Yeah, so if you get a foreign buyer, feel free to call us, because we go through all this 3 or 4 steps to make sure that they don't get stuck on one of them, because you can do a lot of work and then it stops. In fact, you can even get stuck with the spec tax on a foreign buyer, because they're making their money in the United States. Let's say the husband makes all his money in the United States, the wife they're both gonna live here, they're gonna pay the spec tax every year, 2%, which I think might be going up to 3%.
Well, they live here, but they're like making money in the.
Yeah, if you make money in a different place and you pay taxes in a different place and you're a Canadian citizen, you're paying the spec tax. So that's just crazy. Yes.
Yeah, so I'm trying to over to you. And is it true that you can buy as long as your comes in a year?
Yes, you pay the tax, but you get it back.
Buy.
No, you can buy it.
Okay,
If there's an exemption, like in other words, if you buy, well, assuming you get by the foreign buyers ban, okay, so for some reason you're exempt, your spouse is a Canadian.
Can you buy as long as you get your PR within 12 months, or if it's during the
So that's like a two-part question, because for the ban, they need some exemption to get by the form.
Okay,
First.
is the exemption that it's the application is approved?
So that, what you're talking about is for actually the foreign buyer's tax. So if you have to get by the ban first.
Okay.
So if they have a work permit or whatever, you get by the ban. And then
Got it.
with the foreign buyer's tax, yes, they're gonna pay it. But if they get their PR card within 1 year, they can apply to have that, additional property tax.
Okay, so it's just through the ban,
Yes.
which would be a permanent student.
Student visa, work permit, one of the parties is Canadian citizen. Or But the kicker to that thing about gambling, and you pay this huge 20% tax, you have to get that PR within the year. If you're a day over, too bad. And then you have a 6-month period. Like, they won't give it back. We've had clients where they got the PR like next week, so we closed today. And we said, okay, let's apply to get that guy's 20% back. No, you have to wait a year till you apply. Then you have a 6-month window, and if you don't apply during that 6 months, you're gone. So they make it very difficult to get your 20% back.
Wow.
Yeah.
Didn't know that.
So that's just something to be.
I haven't, pending clients, the question was, and I looked up for them, the financing, but then the question is, one of them is not a PR yet, but the husband is a Canadian citizen.
Mhm.
So the husband wanted to put the wife on the title.
Mhm.
She would be taxed, right, for half of the.
Yeah,
if
she
she's not
gets
a
that
PR.
with a 20%.
Because that's what I found out.
And that's what this was, Mel was just saying, that we used to say, well, we'll just put the wife on for 1%, so you're gonna pay 20% on the 1%. That's a big red flag now for the.
But then
property
after
transfer
closing,
tax.
when she gets her PR, can they add her to? the
Oh, yeah, yeah,
So,
yeah.
Did you just say that, you have to apply to get the money back within 6 months, but you can't get it for a year?
That's right.
Yeah, so what happened, this is one of my clients that this happened to. He got his PR card within 3 weeks after we closed, so I submitted the application right away. And they emailed me back saying, a year has not passed. You are not allowed to submit this application until a year has gone by. So I had to reschedule it, submit the application after a year. And then you have 6 months from that year date to.
Oh, from that year.
From that.
Okay, I thought you
To
were
get
saying
that.
6 months from the closing.
So stupid.
and
No.
You don't get your money back that year.
From that
We're
year.
gonna take 18 this year.
But you have to do it within 12 months, but you can apply till the 12 months. And then 6.
Okay, and they wanna see evidence that he's been to the property, so driver's license, utilities, they want everything,
Seriously?
so. Yeah, so make sure you find documents, everything,
Yeah,
as
yeah,
just proof that they live there.
That's insane. It's really insane.
Okay, so these flipping taxes, we had some questions about BC flipping tax, federal flipping tax. The interesting thing is, they're kind of useless right now because properties are not going up in value. So really, it's the same old story. The government comes in with legislation so late, it's a waste of time. And it's just another bureaucracy for nothing. Nobody's flipping stuff now and making money. Okay, so bottom line is, yeah, there's a federal flipping tax and a BC flipping tax. One is 2 years, one is 1 year. Does anybody have any questions on those?
Yeah, it's just on the lift, isn't it?
Yeah, it's just.
If there is tax, it's only on the lift.
We're only on.
Right. Yes.
And it depends on.
Yeah,
But then for the 2 years, they'll have to.
Pretty funny.
it starts reducing.
I was looking
So
for
by
the
the end of the
tax.
second year.
Like, cool.
But the bottom line is right now, most of the stuff isn't going up, so this is why I say both taxes are kind of too little, too late. And besides, you already pay enough tax already.
What about an assignment?
Are triggered by this, so if you have an assignment of a pre-sale and there is profit being made there, and it happens within the 2 years or 1 year, they are gonna get hit with the flipping tax on the left.
Now, from the point at which you signed the offer to purchase, or from when they close it, or when they implement it?
So typically, it's from when they sign the original. A year from, if you just signed the original like last year, and you're trying to sign it now, then you're probably gonna get, well, if you make some money, it's like.
But if it's 2 years after the, offer to purchase, then no thing.
You should be okay.
But if they signed it 5 years ago, please say, here, but then we have to.
Yeah, it's retroactive in the sense that even if you signed it before the flipping tax came into force, you're still caught.
You're still, yes.
Right. So again, just to make things confusing, these are all different rules for different statutes. Some are retroactive, some are not. And some, like for example, the foreign buyers ban, if you signed a pre-sale purchase before it came into effect, you're fine. But so if you signed a pre-sale 5 years ago and you're a foreigner, you can still buy it now. Because you entered into it before. So every government has their own rules. What's a first-time buyer? What's not a first-time buyer? You're a first-time buyer for this legislation, but not for that. For this federal law, but not for BC law. Your common law for 1 year. Another legislation in BC or common law for 2 years. It just makes it very difficult. But as I say, if you have a question, call us because we can always check it out. And the worst thing you can do is give clients wrong advice. Which is just wrong. Okay, so you're exempt, no, you're not. And then they find out later and they sue you. The whole point is, I've said this like 50 times, every surprise in real estate is bad. Every single one. It doesn't mean that as long as you know, you can make a decision, yes or no, but don't tell me later that I'm not exempt. Because your clients don't know any of this stuff, flipping tax and, foreign buyers ban, they figure So you don't have to know all the details, you just have to know the issue. You can always ask us and say, okay, well, here's the facts, what do you think? Because again, sometimes you jump the first 2 hurdles and you get caught by the third. Still not any good. So your client, what we find is the vast majority of real estate deals, you guys probably, it's your experience, they close. Everything closes. Like very rarely does it not close. But what does your client think at the end of the day? Did my realtor do a good job? Would I recommend it again? Would I come back again? So we're the same as you guys. We always get the deal closed. Right? We want to make sure the client's happy. The client had a good experience. The client likes us. The client likes you. So that we come back. So otherwise, none of us will stay in business. You can't get referrals. You can't get repeat clients. You're not staying in business.
Especially with assignments, that tax wise with assignments now with these flipping taxes and now GST being turned on every single assignment. Just be mindful of that, because it does have that GST inclusive clause. If you're acting for a signer, you might want to cross that out and have the buyer pay GST on the lift.
But except in this case, now the lift is negative. You're actually seeing people assign contracts and leave the deposit on the table.
Yeah.
Or leave a good chunk of the deposit on the table. Just take it off my hands. So I can't or won't close.
Yeah.
So it's a totally different thing from 10 years ago where people are flipping this stuff and making a whole bunch of money. Honestly, I think those days are gone.
Yeah.
Which makes
True.
Any other questions, guys?
Thank you, good there. Okay, no more questions for me for another month. You can't hear.
If you don't mind, you can send us an email or call us at 24/7, that's no problem.
Oh.
Yeah.
Kenneth, we deal with him, he's drive home.
Well, not quite.
Well, on
Signing of
today, this time.
Yeah.
No, just like that.
Yeah.
So with assignments and pre-sales, just two things to keep in mind is that you have your standard real estate board assignment contract that you normally sign. The developer will have their own. So they have to sign both. Developer has to consent and there's normally a fee that they charge on that. But mainly it's the taxes that you want to be mindful of with these assignments. And like Ken said, with the flipping taxes right now, not really much to talk about, but the GST, watch that.
No, is there still the clause that if Chris buys an assignment, Chris signs buys a pre-sale, assigns it to Mike, Mike can't close, it goes back to Chris?
Yeah, absolutely.
Okay, remember that.
Every assignment contract, certainly you'll see from the developer, the original guy stays on the hook.
Yeah.
And that's been since Jesus was a cowboy in these assignments.
It's true. So,
When I signed it to you, then you can't.
yeah, so
Yeah.
yeah, if you can't or don't complete.
Yeah, you completed it, still not.
So your assignment will have one of those two assignment documents, as Mel said, the developer has their own, you guys have your own, you're gonna sign both. The only one the developer cares about is their version says they get the assignment fee and everybody stays on the hook.
Yeah.
Okay, whereas yours has all kinds of other stuff, transferring the deposit, this, that, and the other thing. The developer doesn't care about that. So the thing about it, is from you guys' point of view, so there will be a clause in the assignment saying that the guy who assigned it to you, and now he can't close, he's on the hook to you, but you're still on the hook to the developer.
Oh, nice.
So always remember that, you're still, you're not done until it closes.
Okay.
Yeah, and we've had situations where the assigner has been leery and the assigner is gonna close it. So when they come into our office, is do you have the money to close it, or are you prepared to close if this happens?
Mhm.
And they still have to be. If that guy doesn't close, then like you said, you're.
Signer and check the deposit.
Right, and so one thing people ask us, is it more expensive legal fee wise when you do this? Yes, it is, because there's two transactions. There's you, your new guy, your client buying from the developer, and your client assigning from the original buyer. So there's actually two files. Okay, so it's the same cost, no, it is. So you have to now deal with the other side, and you have to deal with the developer.
One final question there. If they don't close, they lose their deposit, but the developer can go after them for loss of.
Yeah.
Whatever, so there's still a lawsuit there where they can lose more than their deposit. Well, that's a consequence, it's a possibility too.
Yes, and so keep in mind these days, guys, that deposit of 10 or 15% doesn't always cover. We've had clients just in the last few weeks, one guy left $350,000 on the table. He thinks that's gonna cover it, but the developer is now trying to resell the property. Maybe it'll cover it, maybe it won't. Got another client, he's gonna leave $2 million on the table, and that might not cover the loss for the developer. So this is today's market, stuff is down, it's not everybody's making a 30% profit, so keep that in mind. The law in BC is very clear, you don't close, you lose your deposit and potentially more.
Great.
It's been a while since I was wondering what update is an average, like, how much it's gonna cost, buyer or seller, how transaction, it used to be around 1,500, now 2,000.
Yeah, it's usually around $2,000.
Okay,
Yeah, registration fees go up every year, so the point that they're. An average buyer's looking at what, $500 to $700 alone and just registration disbursement costs? That's not even our. So,
Yeah, so everything's going up, title insurance costs going up,
Yeah.
all the land titles fees go up every 4 months, just like
I don't
clockwork.
understand it.
You know, more banks insist on title insurance, so whether you want it or not, banks can title insurance mortgage, it's still not a bad deal if you get title insurance, but just to keep in mind, just out of pocket, not paying for the lawyer or the notary, you're looking probably $700-800. That's just like parts for your car, it's not the mechanic.
that's. More include, I would say 2,200 is
Yeah,
probably.
$2,000-2,200 usually covers the whole thing, but yeah, $1,500 is not gonna do the chicken.
Buyers.
And always beware of some idiot out there saying they're gonna do the whole thing for $1,000. No, they're not. Because when you look at their statement of adjustments, you'll see all kinds of stuff in there that nobody else charges. So they're just moving around the fees.
Yeah, so you'll see a lot of notary do that, they'll take certain disbursements out of their account. Put it right on their statement of adjustments, just so it looks like their account is lower, and that's why they can give you a quote of $1,000 or whatnot. They're still gonna charge it, it's just elsewhere. You're still gonna.
Yeah, we got a question from online. So this is going back to pre-sales, it looks like. So if the original contract is done, I'm assuming completed, before the new higher GST exemption for new build, if a new client is taking over the contract today, would they qualify for the 1.1 million new build GST exemption?
I don't think so, because there's a limit. First of all, that's not law yet. It
Yeah.
will hopefully come into law this month.
Maybe.
The Parliament just started sitting yesterday. So Carney and Polyev both agree that this GST 1.1 million is a good idea. So it should get passed this month. But they have, I think it's May 26th or May 28th, it's only applies to contracts after that date.
After that.
So if you signed a pre-sale last year, too bad, you're not
Yep.
getting it.
So the answer is we don't know yet.
Perfect.
But the
Typical.
law should come in, it should come in the next couple.
That's fair.
So basically, even if it, let's say it's approved, it will.
This year, May
be
27th.
implemented in 2028.
Do we have any other questions? Did that lift your spirits?
Maybe. Maybe. Still time to change.
So guys, this is what I'm talking about. This is what I want to keep bringing into these. Hi. To bring into these team meetings, right? And I'll send out the emails to you again about pick a topic that I'd like for you guys to come stand up on the floor and talk about your experiences in all those different situations. So Ken?
Yeah.
Always a pleasure. Thank you. Guys, have a good week. Thanks for coming.